Have you ever heard fantastic claims about a dietary supplement? Has a friend or relative ever sworn to you by the healing powers of some natural remedy? Have you ever found a book that claims that cures to diseases may be found in plant extracts which should be taken in lieu of medicine? I'm sure many of you said yes on all three accounts and thought little of it. After all, those claims are just personal opinions with relatively little impact, right? Well, what if I told you that some supplement dealers purposely encourage and use those unofficial claims to market their products in a dishonest and law-avoidant way? Before we get started, it's vital to understand how drugs, supplements, and the claims attached are handled legally, at least here in the US. The Food and Drug Administration in the US treat drugs and dietary supplements very differently. In the Food, Drug, and Cosmetic Act, drugs are given a comprehensive definition, and two important parts of that definition state that drugs are articles intended for the diagnosis, cure, mitigation, treatment, or prevention of disease in man or other animals, and that a food, dietary ingredient, or dietary supplement for which a truthful and not misleading statement is made is not a drug solely because of the label or labeling that contains such a statement. To be able to market a product as a drug manufacturer must be given approval from the FDA that allows them to do so. This is only awarded after a drug is shown through clinical testing to be safe and effective in treating a disease. The FDA defines a dietary supplement as a product intended for ingestion that contains a dietary ingredient intended to add further nutritional value to supplement the diet. The FDA regulates dietary supplements under a different set of regulations from those covering conventional food and drug products, but suffice to say, they're not tested for safety or effectiveness and cannot legally be marketed as drugs to treat a disease. What's important to glean from all that information is this. Basically, if you claim that your product can treat a disease, you indicate that your product is intended to be used as a drug. However, to be regulated and classified as a drug, your product must be FDA approved based on scientific evidence of its safety and efficacy. A product can't have the limited evidence basis of a supplement, but be allowed to make treatment claims like a recognized drug. If you want the privilege of being allowed to claim that your product effectively treats a disease, that claim must be evidence-based. If a company or individual markets and sells an unapproved substance as a drug, something that treats disease, there can be serious consequences. These include seizure of products, injunction, or even criminal prosecution, leading to heavy fining or incarceration. That being said, supplement dealers are often careful about how they market their products, but the risk involved doesn't stop some from attaching medicinal claims to their goods through weaselly and dishonest tactics. The first of the tactics is one recently used by none other than Aron Hovind of Creation Today Ministries. He used a technique I call literature pairing. This is when a company that sells a certain supplement also sell, or partners with publishers who sell, literature that claims that supplement treats or cures a disease. If you're not the one selling the supplement, you can claim it does whatever you want. There are countless books that claim that all sorts of supplements cure cancer, for instance. So when you are the one selling the supplement, you can find literature that makes great claims about it and then sell that literature in the same place as the supplement. The trick is pairing them at the right distance. To get back to our example, on Aron Hovind's website, he sells B17 amygdalin, as well as a book called World Without Cancer, The Story of Vitamin B17. Now he sells the two products separately, but he used to sell them together as a bundle. That pairing was too close because it earned him a warning letter from the FDA. They didn't like medicinal claims being sold right along with the supplements. If you'd like to hear more about Eric's run-in with the FDA, check out my collab with Paulogia on his channel on the topic. It's a wild ride. Usually, companies pair the products at a legal distance by selling them on the same website. In the cases of chiropractors and naturopaths who sell supplements, which a lot do, literature is often available for borrowing, casual reading, or purchasing in their office. Did you think those books, magazines, and pamphlets were just there for your entertainment? Think again. The next technique is used by countless multi-level marketing companies, and I call it classroom claiming. This occurs when an independent distributor in an MLM hosts and teaches a class about their company's supplements in an effort to sell them, and in doing so, claims the supplements treat disease. MLMs encourage their distributors to host and teach classes about their products, so that they can sell more inventory and sign up the attendees to buy it and sell it as well. They often point to the type of literature we discussed, which can be found on their websites, to serve as inspiration for the lessons. Then, they encourage them to invite friends and family to the class. Now, is it illegal for independent distributors to make medicinal claims about the supplements they're selling? Of course. But the company itself is usually totally in the clear for a few reasons. First, the students of the class mostly consist of the teacher's friends and family, none of which would be very keen on reporting illegal claims made by their loved one. Second, the company never told the independent distributor to make those claims, they just recommended the literature, which the distributor misused. Third, and most importantly, no independent distributor officially speaks on behalf of the company, so if they make illegal claims, they don't represent the company in the least. The one ultimately legally responsible for the claims made is the person who made them, the distributor. So this technique not only allows illegal claims to fly under the radar much of the time, it also gives the company a legal out when those are made. Yet another reason why I absolutely despise multi-level marketing schemes. Now to discuss a technique that seemingly every alternative medicine dealer uses: testimonial pimping. You might have already guessed what this one is about. This is when companies very prominently feature customer testimonials in which their product supposedly healed or cured the user in their official literature and websites. This one is so incredibly easy. One person sharing their story of miraculous healing often inspires others to do the same. Supplement companies just have to feature those stories prominently enough, and they'll always have that free advertising. Cultures often form around the products of certain companies because they're so good at encouraging and connecting people who share their personal experiences. That culture is often very attractive to those on the outside, so potential customers are drawn in by both the claims as well as the sense of community. Plus, sharing customer testimonials is never a legal issue. Companies never have to say a word and essentially always have the defense of, well, they said it, not me. All the techniques so far have relied on outside parties making the claims for the supplement company. But this one actually has the companies making the claims, but relies on the user misinterpreting them. This one is label fluffing. This is when supplements are given names that seemingly indicate a certain medicinal function or are labeled with features which make them look more like medicine. Take detox products, for example. Their names seem to indicate that they'll remove toxins from your body, basically protecting you from poisons you ingest or absorb. Well, guess what? Detoxing doesn't have any real meaning in medicine outside of cases of substance abuse recovery. So as long as detox products don't claim to aid with that, which they don't, then their meaningless claim is allowable. Companies just make sure that that claim doesn't appear meaningless to the average consumer. Another instance of label fluffing is dealers of homeopathy labeling their products with warnings such as, in case of an overdose, contact poison control immediately. This warning implies that an overdose is actually possible and that the product does not consist entirely of pure sugar or water. The label is totally meaningless, but it doesn't appear to be on the surface. Label fluffing is a tactic which attempts to gain a product legitimacy in the mind of the uninformed. It plays on a consumer's assumptions by labeling supplements in legal but highly suggestive ways. Just like all the other techniques, it allows an outside party to suggest a medicinal use for a product when the dealer is legally prohibited from doing so themselves. As I conclude, let me say that I'm not accusing anyone of doing anything illegal here. Using these techniques is not strictly illegal, although some of them probably operate in a bit of a gray area. However, am I saying that using any one of these techniques is still manipulative and morally reprehensible? Absolutely. So I hope what I've said in this video will aid you in spotting scams and critically evaluating claims surrounding supplements and the companies that sell them. And if you ever see claims made in a way that does break the law, please don't hesitate to report it to the FTC. Reporting false claims helps us protect the vulnerable from snake oil salesmen. Thanks for watching. Remember to go check out my related collab with Paulogia if you haven't already. And if you came from that video, let me know what you thought of it here in my comment section. Also, subscribe to my channel if you haven't already. You can follow me on Twitter at GMSkeptic. And until next time, everyone, stay skeptical.